Former President Donald Trump has scored a legal victory in the January 6th investigation, at least for now. A federal appeals court granted Mr. Trump's request for an injunction yesterday, temporarily blocking the release of White House documents that were scheduled to be turned over to the House committee investigating the attack on the Capitol today. A panel of 3 judges will hear arguments in this case at the end of the month. The House panel is also threatening to hold Mark Meadows, Mr. Trump's former White House chief of staff, in contempt if he doesn't appear for a deposition this morning. So for more on this, I want to bring in Nikole Killion, who is at the Capitol. Hey, Nikole, why did this judge decide to temporarily block the release of the documents?
Well, basically, this is just a brief reprieve. And again, as you know, the former president has asked for a longer delay. So in essence, by granting this reprieve now, that allows time for legal arguments to take place for this longer delay that the former president is pursuing. And as you mentioned, that will be heard at the end of this month. So, the judge indicated by no means is this a ruling on the merits of the case, but basically to allow more time for these legal arguments to take place.
And what was the House panel searching for? What are they hoping to find in these documents?
Well, keep in mind, in the late summer, the panel issued a sweeping request to the National Archives and a host of federal agencies. Some of those federal agencies, like the Justice Department, FBI, DHS, have started turning over documents to the panel. But the National Archives, those documents strictly include a lot of those White House records, whether that's call logs, visitor logs, videos, memos, handwritten notes. And so that's really what the committee wants to get their hands on as it pertains to the former president, because they want to know more about his actions and the actions of those around him leading up to the riot, so they can understand, not only the former president's efforts to try to overturn the election, but again, what was really happening behind the scenes before this rally on the 6th and then the riot that ensued.
So the decision about this release sort of gets kicked down the road a little bit. There's going to be a panel of judges that will hear arguments at the end of the month. Can you tell me any more about that?
Well, what's interesting is that all of these judges were appointed by former President Obama. So already, if things don't go the former president's way, I'm sure there potentially could be some finger pointing there. But look, it is what it is. You're assigned the judges that you're assigned, and these are the judges assigned to this particular case. So again, we expect that to go forward with those oral arguments being heard November 30th.
So then, okay, so if this panel of judges at the end of the month decides to release the documents to the House committee, then what happens after that? Does the former president still have more options?
Well, basically, keep in mind the former president has appealed the release of these documents altogether. So really, these oral arguments that are taking place, again, are more about the timetable. So that being said, if things don't go the former president's way and he's not granted this longer delay that he is seeking, most certainly he would likely appeal. His team has indicated as much. A spokesperson for the former president has said that he has always believed that this should be done through the appellate process and that the former president will see this process through. So it's almost certain that the former president, again, would try to contest any decision that doesn't go his way.
So let's move on to Mark Meadows. The House committee is threatening him with contempt if he doesn't show up today. Why is he not cooperating? What reason is he using? And why does the panel want to hear from him?
Well, keep in mind, Mark Meadows was subpoenaed back in late September, and not long after that, the committee said that he was engaging with the panel. He was due to turn over documents and do a deposition in early to mid-October. He was granted a postponement, again, based on the fact that he was, quote-unquote, engaging with the committee. But now it does seem that the dynamic between Meadows and the committee and Meadows' attorney has changed as the committee tries to put more pressure pressure on Meadows to turn over documents. Betty Thompson, in his letter to Meadows' attorney, said that Meadows has not produced one single document since the subpoena was issued. And so at this point, the chairman has said, look, if you don't give us these documents, if you don't do this deposition by today, then you could potentially face contempt charges, because the committee will view that as willful noncompliance. And so far, the only other person who has faced these criminal contempt charges are Steve Bannon. Obviously, his case rests with the Justice Department right now, but you'll recall that Congress took that vote a couple of weeks back to hold Steve Bannon in contempt. Now they're threatening the same for Mark Meadows. And look, we have been talking to members about this for some time, about their frustration level with this particular situation involving Mark Meadows. And I think the general consensus, at least among the members that I've talked to on the committee, is that, look, we're not going to have limitless patience with this. And, this is not a cat and mouse game. So they do want some level of cooperation. And right now, it seems they're not getting that.
Bannon, said he was asserting executive privilege, which isn't a thing for him to assert, because it's only a thing that has to do with the current president. And the current president, Biden, said there's no executive privilege. Go ahead and talk. I don't know if that's the same thing for Mark Meadows, but it just, occurs to me, if executive privilege is not a valid protection, what's the strategy here? Why not, for Mark Meadows, why not just show up and not answer any questions? I mean, we've seen other people do that in front of the panel.
Well, it's possible that could happen. But look, there are two sides to this argument here. And so you have the committee and you have the White House saying that executive privilege does not apply in this instance. But you have folks like Meadows' attorney saying that it does, and that, he is under the instructions of former President Trump in terms of these executive privilege protections, and that in their view, they believe this is an issue that the courts have to decide. And until the courts decide that, then that is why, again, you have the former president wanting to put a hold on this, because it is a legal question in their view, and it's not that black and white. But the committee would argue differently. They believe, and the White House does as well. The White House sent a letter to Meadows' attorney saying, look, the president has already determined that executive privilege is not justified in this instance, and that the president is not going to grant executive privilege or immunity to Meadows to prevent him from testifying. So, basically both sides are, in strong disagreement here. That's why this battle is heading to the courts. And again, we'll just have to see how it's litigated.
Yep, well, I'll be watching, Nikole. Thank you.
You bet.